The field of insolvency includes bankruptcy and economic rehabilitation proceedings for individuals and corporations, creditor settlements, liquidation and recovery proceedings, and insolvency proceedings. All of these proceedings are conducted in accordance with the laws and regulations included under the Bankruptcy Ordinance, the Companies Act, and the Bankruptcy and Economic Rehabilitation Act. The Insolvency Commissioner is an administrative body on behalf of the state, which is responsible for the management of insolvency proceedings, bankruptcy for debtors, private individuals, an authorized dealer, or an exempt dealer who are caught and are or may be in a state of insolvency. The Commissioner for Insolvency Proceedings is in fact a unit in the Ministry of Justice that operates under the Insolvency and Economic Rehabilitation Law, which entered into force on. Issuing an order to open insolvency proceedings is the first step in an insolvency proceeding. Bankruptcy. Upon receipt of the order. In fact, an interim period begins at the end of which a decision will be made whether to issue a debtor for an economic rehabilitation order, which is the last stage of the proceedings, and then a dismissal order will be issued. The functions of the Insolvency Commissioner. The Insolvency Commissioner, also known as the official receiver, is a professional entity with many roles and powers given to him on behalf of the law. Maintaining efficiency, integrity and fairness in bankruptcy proceedings, insolvency and economic rehabilitation, as well as safeguarding the public interest. Appointment of trustees and supervision of their work, while providing instructions and guidelines. Conduct of insolvency proceedings of debtors, an individual, a licensed or exempt dealer. Collection of information regarding insolvency proceedings for the purpose of conducting research and analysis. Every citizen has the right and opportunity to contact the Insolvency Commissioner and receive information regarding cases that are being conducted with him. Removal of various restrictions imposed on an individual in part or in full. What is insolvency law? If you owe money to other people or entities, or in case others owe you money, it is important to be familiar with the insolvency and economic rehabilitation procedure. In the State of Israel, the law allows both debtors and creditors to apply for proceedings during which an agreed portion of the debts will be repaid. In 2019, a new reform came into force, whose purpose is to shorten and streamline proceedings, create a balance between the interests of the debtor and those of the creditors, and delimit the proceedings in time. According to the new updated law, the management of the proceedings will be determined in accordance with the amount of the debts, and there is a distinction between debts that exceed the amount of NIS 150,000 and debts in an amount that is lower than that. What is an insolvency, bankruptcy procedure, and what is it intended for? Insolvency is a financial situation in which a debtor is unable to repay his debts on time. In addition, insolvency is a situation in which the amount of the debtor's debts is higher than the value of all his assets, money and property. A debtor who is in a state of insolvency, or may in the future be in such a situation, may apply for an order to open insolvency proceedings, which is the first step and stage in the process. Even those who owe money, the creditor, has the option and right to request that insolvency proceedings be opened against the debtor. The purposes of an insolvency proceeding: that the creditor will get back his debt, as much as possible, out of all the money that will accumulate in the oblivion fund. Allow the obligor to start a new chapter and page in life, and integrate well and correctly into the economic fabric of life. The creditor may apply to the court to initiate insolvency proceedings against the debtor. It is important to know that filing an application in bad faith, that is, one that is unfair or dishonest, that could harm another, could lead to the cancellation of the proceedings, a charge for expenses, and a criminal offense. Insolvency can manifest itself in two situations. The insolvency has debts and liabilities higher than the value of its assets. The insolvent cannot repay its debts in the short term. Financial debts can make it difficult and burdensome for both personal and business conduct, and they also affect relationships within the family, and the peace of mind of the debtor and his environment. However, if acted upon properly, it is possible to reach understandings and sign a debt settlement with the creditor or creditors. A creditor's arrangement will reduce the amount to be paid to the debt principal and the interest that accompanies it.
Accompaniment and legal advice from an expert insolvency lawyer. Recently, there have been many cases where the Bureau of Execution grants debtors, who meet the conditions of the law, a waiver of all existing debts, and in fact it is a matter of writing off the entire debt. In order to obtain a full dismissal, you must be defined and declared as limited in means. In fact, this is a wrong financial conduct that has led to the formation of large debts of the debtor from which he is unable to get out. In cases where a debtor meets all the conditions set by law, he will be able to receive and enjoy eligibility and the possibility of writing off all his debts to the Execution Bureau, and hence receiving legal assistance and advice from an expert insolvency lawyer is important and may be very helpful in the status of the debtor, in the circumstances of the case, and in the terms of the law. Debt write-off and dismissal. As part of the process of writing off debts in execution, an official notice of the request for dismissal will be submitted and delivered, i.e., the creditors will be allowed to choose whether to accept this option or choose to oppose it within 90 days from the date they receive the notice from the debtor and his lawyer. Once a debtor gets fired, all his debts are written off so that he can start his life anew. In a state of bankruptcy in which a receivership order has been issued, the court can rule and order a delay in the proceedings against the debtor. These are different types of cases such as filing a lawsuit, execution, and more. Delay of process. A stay of proceedings is intended to allow the debtor to conduct his trial when he is free from worries and his duties will not stand as a sword swung over his head. The request for a stay of execution proceedings can be filed from the moment the case is submitted to the court. It is possible to act directly against the execution and submit to it the request to open insolvency proceedings. When submitting the application to open proceedings is the first stop that the debtor should go through in insolvency proceedings if he wants to start a new chapter in his life and be released from all obligations. It is possible to file an application to open insolvency proceedings even in a case where the debtor has debts that have not been opened in the Execution Bureau. The certification and powers of the Insolvency Commissioner. Not every lawyer can be elected to a position in charge of insolvency, as this is a position that requires extensive experience and extensive professional knowledge in the field of enforcement and collection procedures as well as proficiency in relevant legislation. The Commissioner's range of powers is extensive and requires in-depth knowledge of several areas of knowledge, because he is entrusted both with assisting in the economic rehabilitation of individuals and with the recovery of corporations and companies. The Insolvency Commissioner must be knowledgeable in the manner of operation of small businesses and corporations, be familiar with the accepted and prevalent policy in the Employment Service and the National Insurance Institute, as well as gain extensive experience in many debtors' cases. After submitting the application for initiation of insolvency and economic rehabilitation proceedings, the Commissioner has the authority to submit an opinion to its court, which will be of great weight and in many cases according to which the application will rise or fall. Therefore, cooperation and honesty during the Commissioner's investigation is critical to conducting the procedure properly. An experienced and leading lawyer and notary in the field of insolvency. Law firm and notary Shimon Han specializes in civil commercial law and provides a comprehensive legal services package in real estate law, inheritances and wills, insolvency and execution, real estate taxation, insurance claims, and more. Our experienced and skilled team of lawyers will be happy to provide you with advice, guidance, and representation throughout all stages of the process until the task is completed on the best side, while preserving your vital interests and exercising all the rights you are entitled to by law.